Hello everyone, welcome to Court with Krissy. Time for an update. Our least favorite disbarred attorney is back. He's a couple appearances away from getting his own playlist. Right next to Attorney Karen, wannabe Attorney Kevin. As always, if you happen to miss the last appearance, the link will be in the video, and all appearances will be in the description. I hope you like it. Court with Krissy is now in session.
All right. Is this the Prathers on the phone?
Yes, Your Honor. I'm sorry. We have a storm here, and it just knocked me out of the meeting on the Zoom. But I called the court, and she gave me this phone number to add.
Oh. Okay.
Okay. So I'm going to try to get back on, but I'm here. Okay.
Okay, if I see you in the waiting room, I'll bring you in that way as well.
Thank you.
And then just let me know if you're having any trouble hearing what's going on, okay?
Okay, thank you very much. Thank you.
Sure. All right. So let me bring in, we got a couple other people signing in here.
Okay.
Okay, so I think we've got everybody connected. I'd like to address, because we have both files set at the same time here, but I'd like to address the Northern Mutual versus Prather file first. That's file number 2419867. If I can have the counsel on that file put your appearances on, please.
Casey Majestic on behalf of the plaintiff, Northern Mutual Insurance Company.
Kevin Raymond in pro per.
And then Ms. Prather is present here by phone. They've had some connection difficulties due to weather, but she is present by phone. This is set for, it looks like Mr. Majestic, you're asking to have the file dismissed. Is that correct?
Your Honor, there have been some updates since I filed the motion to dismiss without prejudice. We've reached settlement agreements with both Mr. Raymond and with the Prathers. The Prathers, however, aren't willing to sign stipulations and orders to dismiss the cases with prejudice. This morning, they had forwarded me stipulations and order to dismiss that they had signed, but they had attached long affidavits that were inappropriate and said they were part of the signature, so I don't feel I can file those stipulations and orders as they are. Mr. Raymond had previously signed those, but I can't attach another document and represent that he had signed off on that, Your Honor. We had asked for a dismissal with prejudice based on the release, but I would like Ms. Prather to confirm that we have a settlement on the record before we do so. It's a confidential settlement, so I don't want to go into the terms of the settlement, but I would like her to confirm that we do.
All right, Ms. Prather, were you able to hear that?
Yes, Your Honor. I did sign the stipulations. I did want to add the affidavit. It's not a long one. I'm not sure why he says it's inappropriate, because I'm not asking for any change. All that I want is it to be on record. However, I'm not an attorney. I did not choose not to have an attorney. We just simply can't afford these legal fees, Your Honor. And I will sign the stipulation how you'd like, but could I just please say something for the record?
As long as you're not going to discuss the terms of the settlement, sure.
No, not at all. No, it's not. Okay. I just would like to say that my husband and I have agreed to the settlement and stipulation to dismiss the cases, but I just wanted to make it clear that we did have strong documented evidence, permits, emails, and photos that fully disprove the claims against us. Unfortunately, the court never had the chance to review that evidence, so we chose to settle only to end the long stress of almost 2 years and costs of defending ourselves against not only the claims against us, but its joinder with unrelated defendants. This process has caused great hardship. I also believe that Mr. Raymond has shown a pattern of using the courts in ways that harm others. And I say this not to argue the case, but to just ensure our experience is part of the record. I thank you for letting me speak.
Okay. All right. With that, then, Mr. Majestic, are you satisfied that there is an agreement to settle the case?
I am, Your Honor. And we were asking for a dismissal with prejudice and without costs as to either of the defendants.
Okay. So, and did you submit a proposed order already on that?
I did not, Your Honor. We did not have a settlement with the Prathers at the time I filed the motion, so the proposed order would read without prejudice rather than with prejudice. However, one slip of the pen would change that to with prejudice.
Okay, so I'll sign that once that's been presented. If you can submit that under the 7-day rule, please.
Thank you, Your Honor.
Mr. Majestic, is there anything else that you need to address on that file?
I don't believe so, Your Honor, although I'm not a part of the underlying case that Mr. Raymond had filed. It's the same situation in that case as well.
Mr. Raymond, on this file, is there anything further that you needed to address?
No, Your Honor.
Okay.
Your Honor?
Yeah.
I'm sorry? Okay. Would I be able to submit that affidavit or no?
That's not really going to be part of the court file. And, you know, I appreciate that you want to make it a statement for the record, and I've allowed you to do that. But that's from a standpoint of the legal pleadings, I think Mr. Majestic's correct. It's not something that, it's really your own personal commentary. And that's not really something that belongs in the pleadings. So.
Okay, thank you.
Okay. So that addresses that file. The court will consider that Northern Mutual versus Prather and Raymond is now closed, pending, of course, the signing of that final order. So now we'll move on to Raymond versus Johnston and Prather, and that is file number 2319394. We have a similar motion from Mr. Raymond in that case to dismiss the Prathers. Mr. Raymond, anything that you wanted to state for the record on that? So you're muted, Mr. Raymond.
Thank you, Judge. I have a bit of a cough this morning, so I don't want to bother everybody with it. But I don't have anything further to say in light of Mr. Casey's acknowledgement that the Prathers have agreed to that dismissal.
All right, Mr. Couch.
Your Honor, I have no position with regard to the claim by Mr. Raymond against the Prathers.
Ms. Prather, is there anything you wanted to say with regard to that matter?
No, it's the same. And I guess they heard my statement, correct?
Yes.
Mr. Couch, okay, that's so I guess it's the same in regards to that. Yeah, it's the same as we settled, I guess, and just want it on record. Thank you.
Okay. All right. So the court, Mr. Raymond, for the record, the court assigned that order dismissing the Prathers. So Ms. Prather, you're no longer part of that case. You're more than welcome to remain on the line if you'd like to hear the remainder of the proceedings.
Okay.
But that's
yes,
up to you.
Yeah, thank you. I would. Thank you.
I'll be logging off, Your Honor. Thank you very much.
Thank you.
Thanks,
and then
thanks, Casey.
What we have left then in that file today, there was an order that was submitted under the 7-day rule resulting from the motions at the last hearing submitted by Mr. Couch. Mr. Raymond objected to some of the verbiage in that order and submitted his own proposed order. So Mr. Raymond, I had a chance to review all that. Anything you wanted to state for the record?
Just briefly, Your Honor, because to my knowledge, there was no response opposing my objection filed. So I assume maybe we're all in agreement on it. But as to Mr. Couch's order, he did not express clearly that the judge had granted summary disposition to plaintiff with regard to the zoning violations of the rope fence. So I think my order, the first paragraph clearly states that, and the reasons for it that the court stated on the record. The second part of my objection is the way that Mr. Couch stated the court's finding with respect to the rope fence would have precluded a finding of negligence, which is not consistent with the court's ruling. The court's ruling found that it was a zoning violation, and so that at least is evidence of, excuse me, a per se negligence. So my second paragraph just simply says what the court said. You found that there was no evidence that the rope fence was constructed as a incident of trespassing, and you dismissed the trespassing claim. And that's clearly stated in my order in the second paragraph. The third issue I took with Mr. Couch's order is that he expressed commentary about what damages are permitted. And there certainly was a discussion of the court. And I had noted to the court that I wasn't prepared to discuss the issue of damages, whether it be consequential or direct or economic or indirect or non-economic, because Mr. Couch had not raised that issue in his motion. And I cited in my objection the part of the court rule that says he has to specifically state each issue that I have to respond to. The court did take it up, had mentioned that clearly economic damages would be allowable, and wasn't sure as to non-economic is how I remember the court reading. I did try to go and take a look at the transcript that was filed, but the court or the file had already gone to you this morning, so I didn't get a chance to read that. My memory is the court said, I looked at it, economics allowed, non-economic, I'm not sure. Be that as it may, there was no discussion of direct or consequential, and it certainly wasn't in the motion. So I do think that's proper and would be a good use of the court time to have that issue resolved pre-trial, but that would be something I would suggest would be more by way of motion in limine. And so I think my paragraph 3 clearly states there's a fact question presented by the evidence, and therefore the damage to the driveway claim remains. Thank you.
Thank you, Mr. Couch.
Very briefly, Your Honor, as the court probably knows, the two proposed orders are quite similar. As Mr. Raymond just pointed out, he took exception with the final paragraph or final sentence in paragraph 3 of my proposed order that indicated that the plaintiff's damages would be limited to economic damages only. I do believe that that was part of the court's ruling in the last hearing on June 2nd. And, with regard to the rope fence, I simply drafted my proposed order based on the allegations that Mr. Raymond included in his complaint, and that paragraph alleged both negligence and trespass with regard to the rope fence. So when the court granted partial summary disposition to my clients on that, that's why I included the word negligence. But again, the two proposed orders are really quite similar. I understood Mr. Raymond's main objection to be the reference to the limitation to economic damages.
Okay. Thank you. All right. I did have a chance to review both orders. I did have an opportunity to look at the transcript coming out of the June 2nd hearing. And I find that really the only change, I don't have any objection to Mr. Couch's order with regard to the fence. I think it's accurate. I think it does accurately reflect the ruling of the court on the record that day. I do find, though, that as to the third paragraph, in particular the sentence that plaintiff's damages in this regard would be limited to economic damages only, having reviewed the transcript, and this is really my fault, the court should never do this, and that's just make unsolicited comments about what it thinks the law might or might not be, which is what I did. And so that I did not make a finding that it would be limited to economic damages. I made a comment that I didn't think they would be available based on the the limited research I had done during the break at that time. Again, I caused my own problem in making that statement, but I do think that sentence is inaccurate and should be stricken from the order. I do agree, though, that I think that's a legal issue, what damages would and wouldn't be allowed. And so to the extent that either side wanted to raise that as an issue prior to an evidentiary hearing in this case, I think that would be appropriate, because I do think that's a legal issue that got to be decided. But in terms of the objections, the court's denying the objections, except the objection to the statement that plaintiff's damages would be limited to economic damages only. So Mr. Couch, since most of the order is going to remain and it just requires the deletion of that one sentence, I'm just going to ask that you resubmit your order with that sentence omitted.
Thank you, Your Honor. I will do that.
Okay. And that brings us to our final issue, which is a status conference in this case, and that is, where do we go from here? Mr. Raymond, on behalf of the plaintiff, how do you want to proceed going forward?
Judge, I don't know if you, I'm not sure I understand the court's previous rulings. I don't want to just sit back and then file another objection. We didn't really address part of Mr. Couch's order regarding water damages. The water damage issue that was ruled on by the court was as to making a finding pursuant to Mr. Couch's previous motion, first motion for summary disposition, that because plaintiff didn't offer expert testimony, and they did have expert testimony that made a conclusion that the Johnstons' activities did not, the Johnstons did not increase water flow onto Raymond's property. And the court accepted that and made that the ruling. Now, that didn't deal at all, and the court specifically said this doesn't deal at all with the driveway claim, the claim of damage to driveway. And just to refresh the court, Your Honor, I know it sounds like we're rehashing it, but it's a significant point. There was two main issues that I claimed. The Johnstons elevated their property and removed the drainage ditch that was installed as part of the new construction drain plan for both properties. Then there was a second one that was not part of that first motion, and that is that they changed the direction of the pitch of my driveway and reversed it so that the water, like the witnesses I provided to the court testified, if any water came onto the driveway, it flowed to the south and away from my home into a catch basin that was installed there. So even though the court ruled that I haven't proved that water flows onto my property because of what Johnston's did, there was never a discussion about a equally important issue, and that is the water that does flow onto my property. Let's say it's not the Johnston's fault, but the whole nature of this kind of a claim is they changed the direction of the flow. So it used to go into a well, and now it goes into my house. So Mr. Couch is trying to pull a fast one. Nothing improper with that. He's doing a good job, advocating for his client, but he's trying to slip in that I can't claim as a consequence of changing the pitch of my driveway that the water that naturally flows onto my property, no fault of Johnston's, now comes into my house as opposed to going away. And the order, if you don't accept my order and you just have him strike the one sentence, it would change everything. It would now say Mr. Raymond can't show the videos and the pictures and all the stuff of the water flowing down his driveway into his house, and he can't put in his witnesses that were submitted with both both motions for summary disposition that say all the water used to go away. And I can't submit the evidence of Ms. Van Sumeren, who said she watched him, she heard him admit it, she heard him apologize to it, she saw the consequences. So that it's the whole case again in a nutshell. The court didn't rule that I can't prove what would be consequential damages of changing the driveway. And so again, I appreciate the court. I know you moved past that, but I didn't. I'm asking the court to enter my order or to have that provision struck too, that I can't prove the consequences of the change to my driveway.
Thank you. Mr. Couch?
Thank you, Your Honor. The court addressed this argument by Mr. Raymond on June 2nd. I had expressed concern at that hearing that he's trying to backdoor his water damage argument with this driveway trespass claim. The court previously very clearly ruled that the only claims that are going forward do not involve any claims of subsequent water damage to his cottage. I would ask that the court, still allow the order, as the court just indicated a moment ago, the order that I submitted to be entered.
Yeah, so I think it's, in my view, the court's been very clear all along with regard to each of the motions that's been filed, and that is it's dismissed all claims relating to water damage. What we're left with now is a claim relating to the Johnston's entry onto the driveway with their tractor and whether or not there are any damages resulting from that. The court has consistently excluded and granted motions for summary disposition with regard to any claims that anything that the Johnstons did or didn't do on their property is resulting in the water damage for the reasons I've already stated for the record, and I'm not going to go through it again. So in my view, the damages would only be related to those caused by their use of the tractor on the driveway, and damages unrelated to the water damages that have been claimed. So that's why I agree with Mr. Couch's order, and I disagree that any claim for water damages resulting from anything that the Johnstons did or didn't do still survives. I think the court's been very clear that those claims have been dismissed as part of summary disposition. So in my view, unless the parties want to set a deadline for filing a motion as to exactly what types of damages might be allowed on that remaining claim, we should set this for a hearing on the damages issue and get this resolved. So I think maybe now that we're talking about it, I am going to set a motion cutoff for 60 days as to the legal issue as to what types of damages would be allowed for trespass. And by that, I mean whether it's economic damages. You know, at the last hearing on June 2nd, Mr. Raymond, you were claiming some non-economic damages, and that's where the court made its kind of off the cuff comments. But in my view, that's the legal issue, is whether it's economic damages or non-economic damages would be allowed for their trespass onto the driveway. So we'll allow 60 days for any motions with regard to that to be filed and heard. And then with regard to damages, how far out, Mr. Raymond, would you like the court to set that beyond that 60-day period for the evidentiary hearing as to damages? Mr. Raymond, you're muted again.
I'm sorry, Judge. I thought your first order was 60 days to file that motion.
Correct. Beyond that, how much time do you need to be ready for an evidentiary hearing as to damages?
Oh, I don't know, another 60 days, maybe after the ruling.
Okay.
And Judge, just for the record, you've said the last few. Oh,
go ahead. Go ahead, Mr. Reed.
Yes, Judge. The last few. Thank you, Judge. The last few statements you've made have indicated that I can only move forward with damages for trespass. I understood the court's previous ruling to be that my claim that damage was caused to my driveway by the tractor intentionally, they reversed the direction of that that's not how I wanted it, and that I am permitted to present my case of damages as to the damage caused to my driveway, not just trespassing, but physical property damage.
I mean, the remaining claim is trespass.
Well, you ruled at the last hearing, Judge, that I had proved, or at least raised the question of fact, that they intentionally damaged my driveway.
Right, by the trespass.
And trespass, yes.
No, by the trespass. That's the claim that's remaining. It's your claim. You're the one who pled it in your complaint, a claim for trespass for them entering onto your property with their tractor.
I pled that they also changed changed it, and that caused me damages.
So, Mr. Raymond, you're continuing to try and get your water damage claim in when I've clearly ruled that the Johnsons are entitled to summary disposition on any claim that anything that they did or didn't do caused water damage to your property. And you're continuing to try and use the remaining claim to try and reintroduce that element of damages, which I've ruled against. So no, I'm simply not going to allow it. What's left is, did the entry of their tractor onto your property, onto your driveway, cause some type of damage to your driveway?
Okay, well, that's kind of merging the property damage and the trespass. That's fine, but just Judge, this is the first day.
That's what you pled. That's the claim that you pled, and that's the one I found is the only one that's surviving.
Okay, so Judge, just so I want to clearly state, this is the first day we've ever talked about water damage caused by the change to my driveway.
I'm not gonna keep having you're completely misrepresenting everything that's happened for the last year in this case. This is not the first time. This is the first time you're trying to shoehorn your water damage claim onto something that you, as you pled it, didn't have anything to do with water damage. So I'm sorry, and I'm not going to argue with you. That's what remains. That's what we're going to go forward on. So the court is going to set this for a motion cutoff as to the legal issue as to what types of damages are allowed for trespass at 60 days. The court's going to set this for an evidentiary hearing as to damages for 60 days following that. And that's how we'll go forward. Mr. Couch, are there any other dates that you would like to request at this time?
Just a requested clarification on the deadline to file the motion. Given other matters I have on my calendar, may we have 60 days to file the motion? I thought I heard the court say 60 days to file it and have it heard. If we may have 60.
I'd like to get this issue settled. I don't think it's a complicated legal issue, really. I mean, what damages are allowed for trespass, I think, is a pretty straightforward thing. We're doing these hearings by Zoom. If you need to have some other counsel cover that argument for that motion, I'd like to get this case resolved. So
I can do it, Your Honor.
All right.
And then Your Honor also referenced an evidentiary hearing. Is that's not in lieu of a trial on his remaining claim, is it?
I think Mr. Raymond's probably made a jury demand. So I think that would be a jury issue as to the damages. So yeah.
Okay. All right. Which I suppose, since we're having a pretrial conference, brings the court and the parties to the next topic of, does the court want to set this matter for trial, to hold the parties' feet to the fire and have a date out there, or?
Yeah, so I guess when I say evidentiary hearing, I mean, that's what I'm talking about is 60 days following the 60-day motion cutoff would be the date that the court would set this for a trial as to the damage issue.
Okay. All right. Your Honor, I do have a couple of other trials that I'd like to make the court aware of. Can we work with the clerk's office to schedule that trial on this case?
Yeah, if either of you want to contact Jennifer, my assistant, and let her know dates that you're not available, then we'd be more than happy to schedule around that.
Thank you. And
then the other thing that the court, just so the parties are aware, the other thing that this will be set for is on the motion day prior to the trial date, the court will set this for a final status conference where we can discuss the kind of the procedural aspects of the trial in terms of the composition of the jury, exchange of final witness and exhibit lists, and so forth.
Thank you, Your Honor. In Your Honor, since we're discussing setting it for trial, I have to let the court know one of my clients is scheduling surgery, and it's going to be pretty invasive surgery that will take time to recover from. Is that something that we can discuss with Jennifer when we're trying to schedule this?
Yes, absolutely.
Thank you. Good, because last time I spoke with my clients, they were going to get an update from the doctors, and I should definitely know more soon and when we speak with Jennifer. So thank you, Your Honor.
All right, Mr. Raymond, anything further from your side today?
Just, Your Honor, I'd like to state on the record again. I would ask that those hearings, I've asked for each hearing to be done, that at least I be allowed to attend in person. I think I have that right, especially at an evidentiary hearing and a summary disposition hearing. I've been told that the court's not set up to do that. I just want to make sure it's clear on the record that I've been requesting that they get set like that, and I would continue to ask that they get set like that so that I can come in person and present my case to the court.
So the jury trial certainly will be in person. The court sets all other hearings and civil cases by Zoom per the court rule. Mr. Raymond, if you want to request those to be set in person, then I'll just ask that you file a motion pursuant to the court rules on that. As far as I know, you've never filed a motion to have these hearings set in person.
I read the court rule to say that I just need to request it in writing, which I've done each time.
I don't think that's accurate, first of all. And second of all, if you want to have these hearings set, hearings that are presumptively by video conferencing technology under the court rules, you need to file a motion. So the court will set out notices, the deadlines we've discussed today. Again, Mr. Couch, I'll just ask that you submit that order as we've indicated with the change, and all parties are free to disconnect at this time.
Thank you, Your Honor. Take care, Kevin.
Yep, you too, Dave.